Welcome back to the second part of our program. We're going to start by looking at a couple of important bankruptcy law decisions that could have significant effects on practice in that area. First, Midland Funding LLC versus Johnson. Elida Johnson filed for bankruptcy under Chapter 13 of the Bankruptcy Code. Midland Funding filed a proof of claim in Johnson's case, even though the last charge to Johnson's account had been more than 10 years before she filed for bankruptcy. The statute of limitations on collecting that debt was 6 years. Johnson argued that Midland had violated the Fair Debt Collection Practices Act by filing a claim it knew to be time-barred. Evan, you've looked at the bankruptcy cases. What did the court say?
The Supreme Court held that it did not violate the Fair Debt Collection Practice Act for a company to file a claim that it knew to be time-barred. The Supreme Court focused on 5 words in the statute. It said in order to fit as a violation of the law, it has to be false, deceptive, misleading, unconscionable, or unfair. And the court said knowingly filing time-barred claims doesn't fit within those 5 words. The court said it was very reluctant to do anything that would alter the delicate balance between debtor and creditor rights that exists under the Bankruptcy Code.
There was a really strong dissent here, though, right?
Yes. Justice Sotomayor wrote the dissent, joined by Justices Ginsburg and Kagan. She said that companies are intentionally filing claims that they know to be time-barred. She said that she believes this is unconscionable and unfair. She also talked about the burden on the bankruptcy courts when these time-barred claims are filed, and she said there's going to be even more of them in light of the Supreme Court's decision.
Okay. So what about our other bankruptcy decision, Krzyzewski versus Jevick?
This involves the question of whether there can be a structured dismissal that deviates from the priorities that are created in the Bankruptcy Code. What's involved here is a company, Sun Finances, purchased Jevick using money from CIT. Jevick files for bankruptcy under Chapter 11. Employees of Jevick had previously sued it and had a judgment they were an $8.3 million priority under the Bankruptcy Code. But then there's a structured dismissal involving Jevick and Sun and CIT and the creditors that basically gives nothing to these employees in the judgment they recovered. And of course the issue is this structured dismissal permissible? And the Supreme Court said no. A structured dismissal cannot deviate from the priorities set up in the Bankruptcy Code. The Supreme Court said that the priorities in the code are the very backbone of the bankruptcy law, and there can't be a deviation as part of a settlement.
So probably the most important question to the practitioners and to the judges is, does this mean an end to all structured dismissals?
No. The Supreme Court said certainly there'll be instances where structured dismissals are likely permissible. But the court said there cannot be structured dismissals that deviate from the priorities that are created in the Bankruptcy Code.
Okay. Thank you, Erwin. Coming up next, we'll look at liability under Bivens and the doctrine of constitutional vagueness.
Liability is the underlying subject of our next 3 decisions: the liability of federal officers under Supreme Court precedent, and the question of when a criminal defendant is liable for a harsher sentence under the constitutional vagueness doctrine. Ziegler versus Abbasi is the 4th amended complaint filed originally in Ashcroft versus Iqbal in 2004. It has been in the federal courts for so long that Justice Sotomayor had to recuse herself because she had dealt with it and when she sat on the Second Circuit Court of Appeals, and Justice Kagan recused herself because she had dealt with the case as President Obama's first Solicitor General. Abbasi was one of 84 aliens arrested in New York City following the terrorist attack there on September 11, 2001. He was held in the Metropolitan Detention Center. He and the others were detained under a hold until cleared policy rather than being processed through the normal criminal justice procedures. Abbasi and the others brought the original claim alleging that the conditions of their detention were harsh. The detainees were held in tiny cells for 23 hours a day up to, with little opportunity for exercise or recreation. The lights in the cells were kept on 24 hours a day, making it nearly impossible to sleep, and they were forbidden to keep anything in their cells, even basic hygiene products like soap and a toothbrush. They were strip searched, often, even randomly, and were denied access to most forms of communication with the outside world. And this was all done according to official policy. Unofficially, they alleged that the prison guards engaged in a pattern of physical and verbal abuse, while the jail's wardens turned a blind eye. So Abbasi and the others filed their complaint on their own behalf and on behalf of a putative class seeking compensatory and punitive damages and attorney's fees and costs. They claimed that the government had no reason to suspect them of any connection to terrorism, and they had no reason to hold them for so long in these harsh conditions. They sued two groups of federal officers in their official capacity. The first group included former Attorney General John Ashcroft, former FBI Director Robert Mueller, and former Immigration and Naturalization Service Commissioner James Ziegler. They also sued the detention center's warden, Dennis Hasty, and the associate warden, James Sherman. Now, Suzanna, what were the constitutional grounds for their claims?
Well, they sued on an implied cause of action directly under the Constitution as recognized by the Supreme Court in its 1971 decision in Bivens v. 6 unknown named federal narcotics agents. They claimed they had been detained under these harsh conditions solely because of their race, religion, or national origin. They were all from the Middle East or from East Asia, and many of them were Muslim. And they also brought a claim against the warden under a federal statute that prohibits a conspiracy to violate constitutional rights.
And what did the court decide?
The justices decided 4-2 that there was no Bivens cause of action in this case. The court said the question in an implied cause of action case is a separation of powers analysis. The courts should ask who should decide whether to provide a damages remedy, and most often the answer will be Congress, not the courts. And the majority wrote that a Bivens remedy is not available if there are special factors counseling hesitation in creating such a cause of action, and here there are 4 such special factors. First, when claims are being made against executive officials, a Bivens remedy should not be used to challenge official policy rather than individual actions. Second, national security policies especially counsel hesitation. Third, Congress's failure to act on this question, despite having enacted various anti-terrorism legislation over the years. Congress's failure to act suggests that Congress is perfectly happy without having a private cause of action. And finally, this was not a case, the court said, where it was damages or nothing. In fact, these plaintiffs had a habeas remedy available, and the court thought that might even be a better remedy.
Yeah, and the majority also found that the claim against the wardens for knowingly allowing abuse to take place was similar to the claim in another case where the court had found an implied private right of action, Carlson versus Green, but that it was just enough different not to warrant extending the doctrine to this case. Instead, the court remanded the claim to the Court of Appeals to apply the special factors test. And finally, with regards to the statutory claim against the officials, the court decided that they had qualified immunity because, and I quote here, reasonable officials in their positions would not have known and could not have predicted that the statute prohibited their joint consultations and the resulting policies, end quote.
We should note that the court didn't decide whether the statute did or didn't prohibit such joint consultation, whether it was possible for executive officials to conspire with each other. They just said that this was an open question. It hadn't been clearly established, and therefore the officials still had their qualified immunity.
The court has only found an implied cause of action in 2 other cases since Bivens. One was the case that I referred to before, Carlson versus Green. The other was Davis versus Passman, the one involving the congressman. I think this decision makes it clear that those three cases taken together are really just orphans, and they may or may not ever be overruled, but unless a case presents almost exactly the same facts as in one of those three cases, I don't think the court's going to find an implied right of action.
Okay. Let's get to that next decision, Hernandez versus Mesa. Now, the facts of this case are tragic and well known. A U.S. Border Patrol agent standing on U.S. soil shot and killed a Mexican teenager standing on the Mexican side of the border. Hernandez and his friends were playing a game where they ran up to the U.S. border fence, touched it, and then ran back to Mexican soil. Officer Mesa fired at least 2 shots across the border at Hernandez. 1 shot struck him in the face and killed him. Evan, what happened legally after that?
The boy's family sued in federal court under Bivens for alleged violation of the boy's Fourth and Fifth Amendment rights. The Court of Appeals held that the parents failed to state a cause of action under the Fourth Amendment because their son was a Mexican citizen with no voluntary connections to the United States and who was killed on Mexican soil. The Fifth Circuit en banc was divided on the merits of the Fifth Amendment claim, but unanimously held that Mesa had qualified immunity under these facts. The Court of Appeals didn't reach the question of whether Bivens provided a cause of action on these facts. The Supreme Court vacated that decision and remanded to the appellate court to reconsider its Bivens decision in light of Ziegler versus Abbasi.
And this, I think, shows how important Abbasi is. It's going to be much harder to find an implied right of action after Abbasi.
Let's look at our final case in this group, Beckles versus United States. Travis Beckles was convicted in 2007 of possession of a firearm by a convicted felon. Because the firearm was a sawed-off shotgun, Beckles was eligible for a sentencing enhancement as a career offender under the United States sentencing guidelines. According to the guidelines commentary, possession of a sawed-off shotgun qualifies as a crime of violence under the so-called residual clause of Section 4B1.2a of the guidelines. The district court sentenced Beckles to 30 years in federal prison, and the appeals court affirmed. While Beckles' cert petition was pending in the Supreme Court, the court decided Johnson versus U.S., which struck down the residual clause of the Armed Career Criminals Act as unconstitutionally vague. The 2 residual clauses are virtually identical. Susanna, what did the Supreme Court do in the Beckles case?
Well, Justice Thomas wrote for the majority, which unanimously rejected Beckles' challenge. The majority held that the court unanimously rejected the challenge, but there were several opinions. Justice Thomas wrote for the majority, and he held that the sentencing guideline, because the sentencing guidelines are not binding, they are merely to guide the exercise of the court's discretion in sentencing, they're not amenable to a vagueness challenge at all. However, the court did not decide whether Johnson applies to sentences imposed before 2005 when the guidelines were mandatory.
Justice Thomas was careful to leave open the possibility that the guidelines could be challenged on constitutional grounds other than vagueness. First, they could be challenged if they're applied retroactively in a manner that violates the ex post facto clause. Second, they could be challenged as cruel and unusual punishment if they're impermissibly disproportionate to other punishments. And third, they could be challenged if a sentence imposed pursuant to a guideline were to violate due process generally. For example, if it was based on a material and false piece of evidence. Now, having said all that, I don't think we can infer from this decision alone that the court has narrowed its decision in Johnson just to the residual clause of the Armed Career Criminal Act. The fact that the guidelines are now only advisory makes them categorically different from the mandatory minimum at issue in Johnson. The issue of whether Johnson applies to statutes other than the Armed Career Criminal Act is presented in Sessions versus DiMaia concerning a provision of an immigration statute. The case was briefed and argued, but it wasn't decided, and it's been put over for re-argument in the fall.
Thanks, Evan. Suzanna? We often focus on the big constitutional issues that come before the Supreme Court, but the truth is that the justices probably spend more time interpreting federal statutes. They did that in several instances this term, and we will look at those next.
The court twice took up the Individuals with Disabilities Education Act this term. As you might imagine, the IDEA provides states with federal money to help educate children with disabilities. But what states are expected to provide for that money has led to great confusion in the lower courts regarding the appropriate standard to apply. Our first decision, Andrew F. versus Douglas County School District, takes up a question which the court concedes it declined to address in an earlier decision. In the earlier case, the court agreed that the IDEA established a substantive right to a free, appropriate public education for certain children with disabilities, but it declined to endorse any one standard for determining when handicapped children are receiving sufficient educational benefits to satisfy the requirements of the Act. With the Andrew case, that more difficult issue was again before the court. Laurie, can you tell us about this case?
Sure. Under the IDEA, an individualized education program, also known as an IEP, is supposed to be developed for each child. And that IEP is supposed to deliver what we call a free, appropriate public education, or FAPE. Andrew here was diagnosed with autism at age 2 and spent preschool to 4th grade in the Douglas public school system. But by the 4th grade, his parents were concerned that he was not making any progress and that the IEP for each year was just the same as the prior year. To deal with this situation, he enrolled Andrew in a private school for 5th grade, and Andrew started to make much better progress. When Andrew's parents met with the public school officials about the IEP for 6th grade, again, it looked the same as the prior years, and they then filed a complaint with the Colorado Department of Education asking to be reimbursed for Andrew's private school education. The department denied the request based upon a recommendation by an administrative law judge, and a federal district court judge affirmed, saying that the annual modifications of the IEP were sufficient to show a pattern of minimal progress. Then the appellate court affirmed, saying that all that was required was instruction and services furnished calculated to confer some educational benefit.
So, Erwin, did the Supreme Court agree with that standard?
No, the Supreme Court unanimously reversed the Court of Appeals. Chief Justice Roberts wrote for the court, and he said that the minimal progress standard of the 10th Circuit was not sufficient to meet the IDEA. I think his exact language is going to be very important in litigation in lower courts, so I want to read it. He said, to meet its substantive obligation under the IDEA, a school must offer an IEP reasonably calculated to enable a child to make progress appropriate in light of the child's circumstances.
So, Laurie, do you think this is going to help lower courts in applying this?
You know, it is a pretty broad standard that gives a lot of discretion to the district courts, and of course it depends on the facts in each case. I think the guidance is that it needs to be more than a de minimis standard, but less perhaps than what all the parents would want. It is, however, a very significant decision because so many school districts are now dealing with this issue.
I agree with Laurie about its importance. There's a real difference between the minimal progress standard of the 10th Circuit and what Chief Justice Roberts articulated. I think many parents are going to use this to try to argue that schools have to provide more to their children than the schools have previously been doing.
Okay, thank you. Our next IDEA decision, Fry versus Napoleon Community Schools, dealt with another facet of that act. The requirement that parents exhaust all of the IDEA's administrative procedures before bringing a lawsuit seeking relief that is available under the Act. This case dealt with a child referred to in the decision as EF with a severe form of cerebral palsy. EF had a trained service dog named Wonder that helped her with various life activities. When her parents sought permission for Wonder to join EF in kindergarten, the school officials refused. They felt that the human aid provided as part of EF's IEP made the dog unnecessary. In response, EF parents started homeschooling her. Ultimately, they filed suit in federal court. The district court dismissed the case, ruling that EF's parents had to first exhaust the IDEA's administrative procedures. Erwin, where did the Supreme Court come down on this one?
The Supreme Court again was unanimous, Justice Kennedy writing for the court. Justice Kennedy said the exhaustion requirement of the IDEA only has to be met if what the parents are seeking is a fair, appropriate public education. He said that the only remedy that's available under the IDEA is for a fair, appropriate public education. If the parents are seeking something else, then there's no exhaustion requirement under the statute.
So the key issue in this case is how to decide when a complaint is focusing on problems with the FAPE, the FAPE, or on other disability-based discrimination. To make that decision, the justices gave the following guidance. Lower courts should ask two questions. First, is this the type of claim that the plaintiff could have made in another type of facility, such as a theater or a library and not just a school? Second, could an adult at the school press essentially the same type of grievance? So if the answers to these two questions are yes, and the complaint does not refer to the FAPE, then the complaint will not require exhaustion under the IDEA. And the court remanded this case to see what the application of the test.
I think this is going to lead to a great deal of litigation. Schools are going to always try to argue that what the parents are really seeking is a fair, appropriate public education, so therefore they're going to have to go through exhaustion. And parents are going to try to argue that they're really seeking something outside of a fair, appropriate public education, so they don't have to go through exhaustion. And it's going to come to the courts all the time.
Okay. Our next decision, Henson versus Santander Consumer USA, was Justice Gorsuch's first opinion for the court, and it was a unanimous decision. The question here was, who should be treated as a debt collector for the purposes of the Fair Debt Collection Practices Act? This is the act that authorizes private lawsuits and weighty fines designed to deter the shady and intimidating practices of some debt collectors. In this case, City Financial Auto loaned money to people looking to buy cars, some of whom defaulted on the loans. City Financial sold those loans to Santander, who sought to collect them in ways that Henson and others said violated the law. But Laurie, was Santander subject to the law?
Not according to the Supreme Court. Under the Act, the term debt collector is defined as anyone who regularly collects or attempts to collect debts owed or due another. So while a third-party debt collector hired by the owner of the debt, or the repo man, may fall under the Act, here the court says it does not apply when the person collecting the debt actually owns the loan. And to make that decision, Justice Gorsuch looked at the plain language of the Act, and he rejected any reinterpretation by looking at other statutes that use the word owed in them. So therefore, in fact, it said the Act did not apply because the collector had purchased the loan and was asking to collect on the loan.
Justice Gorsuch said Congress didn't consider whether those who purchased debts should be covered by the Act. So that's a practice that really developed after the Act was brought into existence. I think his language here is interesting in terms of interpreting the statute. He says, quote, "It is never our job to rewrite a constitutionally valid statutory text under the banner of speculation of what Congress might have done had it faced a question that on everyone's account it never faced." He said it doesn't matter whether interpreting the statute this way would serve the underlying purpose of the law. He says in interpreting a statute, the focus has to be on the text and the structure and nothing else.
Okay. Our final case in this group, Honeycutt versus United States, deals with a federal statute, 21 U.S.C. Section 853, that mandates forfeiture of any property constituting or derived from any proceeds the person obtained directly or indirectly as the result of certain drug crimes. Specifically, the issue before the court was whether, under this law, one of multiple defendants may be held jointly and severally liable for property that his co-conspirator derived from the crime, but that the defendant did not himself acquire. The facts of this case help elucidate the issue. It involved two brothers, Terry and Tony Honeycutt. Terry managed sales and inventory for a hardware store Tony owned. They were indicted for federal drug crimes, including conspiracy to distribute a product used to make meth. The government sought judgments against each brother of about $270,000 under the Comprehensive Forfeiture Act of 1984. Tony, the store owner, pleaded guilty and agreed to forfeit $200,000. Terry went to trial and was convicted. The government conceded that Terry had no controlling interest in the store and did not stand to benefit personally from the sale of the product. But it still asked the district court to hold him jointly and severally liable for the profits from the illegal sales and sought a judgment of about $70,000 for the outstanding conspiracy profits. The district court declined to enter a forfeiture judgment against Terry because he was a salaried employee who had not received any profits from the sales. But the appeals court reversed and held that the brothers, as co-conspirators, were jointly and severally liable for any conspiracy proceeds. Laurie, what did the justices say?
Justice Sotomayor wrote for a unanimous court that the statute does not countenance joint and several liability, and that the structure of the statute itself puts limitations on forfeiture. Section 853A1 limits forfeiture to property the defendant, quote, obtains as a result of the crime. And obtains means that the defendant personally and actually acquired it. So the court said the government can only confiscate assets from a defendant who actually acquires the property, and Terry wasn't such a defendant.
This case resolves the question of joint and several liability under the federal forfeiture statute. But the issue of joint and several liability comes up under so many federal laws. This case does not address that. But it does say to courts that in resolving it, they need to look at the text and structure of those laws.
Okay.
We have a news flash here that's happened while we were doing this program, and it may be in response to Erwin's plea for grandparents earlier. It's the Supreme Court says grandparents are okay under the travel ban now.
As a grandparent, I applaud that.
All right.
Thanks. And now to our final panel.
Who can sue? Who can be sued? And how are they judged once they come into court? These are among the questions at the very heart of the judicial function, and the Supreme Court decided several cases this term that deal with these issues. The first one we're going to look at, BristolMyers Squibb versus Superior Court of California, San Francisco County, would have very significant effects. What can you tell us about this one, Suzanna?
Well, nearly 700 plaintiffs, only 86 of whom lived in California, sued Bristol-Myers in a California state court for damages they claimed to have suffered as a result of using Bristol-Myers drug Plavix. 592 of these plaintiffs lived elsewhere, spread out over 33 other states. They didn't buy Plavix in California, they didn't take it in California, and they didn't claim to be injured in California. But the California Superior Court nevertheless found that it could exercise specific jurisdiction over the case because Bristol-Myers, quote, had engaged in extensive activities in that state. And the court said that if the contacts with the forum state were extensive enough, as Bristol-Myers were, then the connection between those contacts and the specifics of the claimed injury could be relaxed. Now, Bristol-Myers claimed that being hailed into court in California under that diluted standard violated its rights under the Due Process Clause of the 14th Amendment.
All right, Evan, what did the Supreme Court say?
Well, the federal Supreme Court rejected the California Supreme Court's standard They said that you can't have a sliding scale where you're mixing and matching the facts that go toward general jurisdiction with the facts that go toward specific jurisdiction. The general and specific categories of personal jurisdiction are separate. Justice Alito said that specific jurisdiction can only be established by connections between the defendant and the forum state that are specific to the case at bar.
So this is a pretty narrow standard for getting into state court on these kinds of cases.
It is, and it continues a trend of contracting the reach of personal jurisdiction. And I think it still leaves open two questions. First, what happens if a plaintiff buys the drug in one state, but then moves to another state, takes it in the second state, and is injured there? The language of the majority opinion suggests that the sale of identical drugs in two states will not give the second state jurisdiction if the drug was purchased in the first state. But it's not clear, that's just from the language. Second, the majority explicitly leaves open the question of whether the Fifth Amendment's due process clause would impose the same restrictions on the exercise of jurisdiction by a federal court while this was a state court. And there's one other thing worth noting, which is that the opinion adopts an approach to personal jurisdiction that is based not primarily on the personal liberty of the defendant, but rather on state sovereignty. What Justice Alito says is that restrictions on personal jurisdiction are a consequence of territorial limitations on the power of the respective states.
What are the broader implications of this, Evan?
Well, according to Justice Sotomayor in her dissent, she says it makes it profoundly difficult for plaintiffs who are injured in different states by a defendant's nationwide conduct to sue in a single consolidated action. And the effect of that, she writes, is to eliminate nationwide mass actions in any state other than the one where the corporation is, in the court's language, at home, which generally is the state of incorporation or the principal place of business.
Our next decision also finds the court reining in what it considers a state court's enthusiastic application of its jurisdiction over a national corporation. This is BNSF Railway Company versus Terrell. Actually, these were two cases against BNSF that were consolidated because they address similar issues. In one, Robert Nelson, who lives in North Dakota, sued BNSF in a Montana state court to recover damages for knee injuries that he sustained while working for the company as a fuel truck driver. In the second case, Kelly Terrell sued the company in Montana as administrator of her late husband's estate, claiming that he had developed a fatal form of cancer from his exposure to carcinogenic chemicals while working for BNSF. She and her husband lived in South Dakota. Neither plaintiff alleged that their injuries arose in or were related to work that they did in Montana. In fact, neither had ever worked for the railway in that state. Both parties had sued BNSF under the Federal Employers Liability Act, or FELA, which makes railroads liable in money damages to employees for on-the-job injuries. So, Evan, how did the employees get into Montana State Court?
Well, the Montana Supreme Court held that there were two distinct sources of personal jurisdiction over BNSF. First of all, it held that Section 56 of the FELA authorized state courts to exercise personal jurisdiction over railroads, quote unquote, doing business in that state. Second, the court observed that Montana law provides for the exercise of general jurisdiction over, quote unquote, all persons found within Montana. Because BNSF had thousands of employees, thousands of miles of track in Montana, the state Supreme Court found that it was both doing business in and also was found within the state, and therefore that both FELA and state law authorized the exercise of personal jurisdiction.
So did the U.S. Supreme Court reject both of those arguments, Suzanna?
It did. It rejected both. It rejected the statutory argument unanimously. It said that Section 56 of the FELA, which says that an action may be brought where the defendant is doing business, is a venue provision, not a grant of personal jurisdiction. But because the Montana Supreme Court had also relied on state law as a justification for the exercise of personal jurisdiction, the U.S. Supreme Court also had to decide whether the state law or the application of state law violated BNSF's due process rights, which means that raised the question of whether the exercise of jurisdiction satisfied the standard laid down in the 2014 decision in Daimler v. Bauman.
And what was that standard?
Daimler limits the exercise of general personal jurisdiction to cases where the defendant's contacts with the forum state are so pervasive and systematic that the defendant is, metaphorically speaking, at home in the state. The two paradigmatic examples of being at home, as I mentioned before, are being incorporated there or having that state as a principal place of business. Although Daimler does also allow the exertion of general personal jurisdiction where a company's operations are so substantial and of such a nature that it is at home in a state, even if that state is not the state of incorporation or the principal place of business. The court found that none of those conditions were present here with respect to BNSF.
All right, this was 8-1, right?
It was. Justice Sotomayor dissented again here. She dissented in Daimler. She disagrees with the at-home standard and would go back to the court's minimum contacts analysis from International Shoe. And she thought that even under that standard, the court should have remanded to the Montana Supreme Court to decide whether the railroad was at home in Montana.
We move now from questions of jurisdiction to questions of standing. Specifically, in Bank of America versus City of Miami, the issue was whether that city had standing to sue banks under the Fair Housing Act that allegedly engaged in discriminatory lending practices. What did Miami claim in this case, Suzanna?
Well, Miami sued Bank of America and Wells Fargo for allegedly setting predatory conditions on loans to minority borrowers. And the city claimed that this led to unnecessarily high default rates and therefore foreclosure rates, and this, it said, led to lower property values and tax revenues and also increased the cost to the city for demand for municipal services to cure the blight and the unsafe conditions. So the case raised two separate statutory questions, and the majority essentially split the difference, giving the plaintiffs a win on one and remanding on the second. The first statutory question was whether Miami was within the so-called zone of interest that the Fair Housing Act protects. Now, this used to be called prudential standing, but since the court's 2014 decision in the Lexmark case, the court has considered it just a general question of statutory interpretation. That is a question of whether Congress meant for that particular plaintiff to have standing under that particular statute.
And did Miami have standing under the FHA?
It did. The majority held that the FHA's language granting standing to any aggrieved person reflected an intent to confer standing broadly, and that the city's claimed financial injuries from the blight were enough to satisfy that.
Evan, what was the second question?
The second question had nothing to do with standing. It had to do with causation. The question was whether the bank's allegedly discriminatory lending practices proximately caused the city of Miami to lose property tax revenue and spend more on municipal services. The Court of Appeals had answered yes, because the city had plausibly alleged that its financial injuries were foreseeable results of the bank's misconduct. But it was at this point that the Supreme Court disagreed. It said the Court of Appeals should not have equated foreseeability with proximate causation under the FHA, because foreseeability is a necessary yet not sufficient condition to find proximate cause. And on remanding this question back to the Court of Appeals, the justices said that that court had to decide whether there is, and I quote, some direct relation between the injury asserted and the injurious conduct alleged, end quote.
The court decided another standing case this term that we also want to tell you about. This was Town of Chester versus Lareau Estates. The question before the court was whether an intervener of right under Federal Rule of Civil Procedure 24A2 must have its own Article III standing to sue. The court found unanimously that it did, at least to the extent that it sought relief not already pleaded by a plaintiff in the original suit. Standing is not dispensed in gross, Justice Alito wrote for the court, and for all relief sought, there must be a litigant with standing. A little background for our discussion in the next decision. In 1978, the court held in Coopers and Librand versus Livesay that a district court order granting or denying plaintiff's certification as a class is an interlocutory decision. Now, that is important because under 23 U.S.C. Section 1291, only final, not interlocutory decisions are immediately reviewable, with one caveat. Responding to the perceived rigidity of the Coopers decision, however, Federal Rule of Civil Procedure 23F was promulgated, giving the appeals court the power to allow the appeal of orders granting or denying class certification if it so permits. So, Evan, how did all that play out in our next decision in Microsoft versus Baker?
The plaintiffs here were denied Rule 23F permission to appeal the district court denial of class certification. But instead of pursuing their individual claims to final judgment on the merits, they voluntarily dismissed their claims, creating an appealable final judgment. But they also reserved the right to revive their claims if the appeals court were to reverse the district court on the class certification question. The Supreme Court ruled unanimously against the original plaintiffs, who were the respondents here, but they didn't agree on the reasoning. Justice Ginsburg's majority opinion, which was joined by Justices Kennedy, Breyer, Sotomayor, and Kagan, ruled on statutory grounds. Justice Ginsburg wrote that a voluntary dismissal under these circumstances is not a final order because allowing such an appeal would undermine what she termed the careful calibration represented by Section 1291 and Rule 23F. She also noted the one-sidedness of this tactic, because if the court were to allow it, plaintiffs could get immediate appeals of denials of class certification, but defendants could not get immediate appeals of grants.
And that difference is critical because the grant or the denial of class certification basically ends the case and establishes the settlement value. These cases just don't go to trial.
What was the other approach taken in this case?
Well, a concurrence written by Justice Thomas and joined by the Chief and Justice Alito agreed with the holding, but they would have ruled on constitutional grounds that basically the plaintiff's voluntary dismissal meant there was no longer an Article III case or controversy. The plaintiffs were no longer adverse to the defendants, and the class certification was a purely procedural question that would lack Article III cognizance.
Finally, one more decision we want to tell you about. Goodyear Tire and Rubber versus Hager et al. In that case, the question was how to determine the amount of attorney's fees to impose as a sanction for litigation misconduct. It is within a court's inherent power to impose sanctions, wrote the justices, but they must be compensatory, not punitive. If a court wants to impose punitive sanctions for misconduct, then there are other procedural safeguards that come into play to protect the alleged miscreant's rights. In the case of compensatory sanctions, a court should use a but-for standard in which the complaining party may recover only the portion of his legal fees that he would not have paid but for the misconduct of the opposing party. Here, the Ninth Circuit failed to apply that standard, and the Supreme Court remanded the case for the District Court to reassess the fees in line with the standard. So, thank you for joining us, and now here is John Cooke.
That's our program for this year. We hope you found it interesting and useful. Please take time to fill out the online evaluation form that you'll find on the same page as the written materials at our website. It's the only way for us to know how we can make this program even more useful for you in your work for the courts. I thank the faculty for helping to explain these decisions and everyone at the Federal Judicial Center responsible for producing this program. I'm John Cooke. Thank you for watching.